For today's story, we are talking about Daniel Perry, and he was driving through downtown Austin during a march that was going on. And in this march, someone might have had a rifle. That might have been an AK, and he might have shot at them, maybe in self-defense. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoyed this legal education content, and today will be the day I earn your subscription. But first, a huge thank you to the sponsor of this video, Aura. Aura is a new type of security service that helps to protect your online accounts, internet connection, and devices with one simple subscription. With an easy online dashboard and alerts sent straight to your phone, Aura keeps you in control and guides you through solving any issues with Aura's excellent customer service. All plans, of course, come with $1 million in identity theft protection insurance and an experienced US-based customer support team that has got your back every step of the way. So if you want to secure your online presence from hackers, scammers, and nosy advertising companies, please go visit aura.com/uncivillaw. And when you use my link below, you'll get up to 40% off all plans. Plus, there's a money-back guarantee. So if you don't like aura.com, you can cancel and get your money back. aura.com/uncivillaw to help you protect your identity and your credit from increasing threats in our increasing digital age. For today's story, we are talking about Daniel Perry, and he was driving through downtown Austin during a march that was going on. And in this march, someone might have had a rifle. That might have been an AK, and he might have shot at them, maybe in self-defense. And he killed somebody in response to that. So this is the scenario, right? We got a guy in a car, Daniel Perry, who's shooting at someone who may have a gun. It may be an AK. He may have been aiming it at Daniel, and he may have shot in self-defense. So the state of Texas has charged Daniel Perry with murder. He obviously is claiming self-defense. So the case is ongoing, but there have been some suggestions from the defense that maybe some things are not going on properly. So we're going to review two orders related to the court. We're going to review a motion for an evidentiary hearing, and we're also going to review a motion to dismiss. So let's get started with this. All right, so first we got a motion to dismiss based on alleged prosecutorial misconduct. As noted in Daniel Perry's previously filed pleadings regarding prosecutorial misconduct, whether or not there's an affirmative duty under Texas law to present exculpatory evidence to the grand jury is an open question in Texas. Okay, so yeah. Nevertheless, there is certainly a legally significant difference between simply neglecting to present exculpatory evidence to a grand jury and repeatedly tampering with a witness and ordering the witness to tailor the testimony in order not to mention a plethora of exculpatory evidence. Yeah, those are definitely two potentially different things, right? So let's talk a little bit about grand juries generally. A grand jury is an investigative process, and to which you only need to show that there is probable cause to get a bill of indictment. So it is part of an investigation process, but it is not as thorough as a process at a regular jury. So does the prosecutor have to present exculpatory evidence to them? Typically, no. Apparently, this is an open question in Texas, but the standard answer is no. They only need to present evidence that would form probable cause. They don't need to present evidence that would show that you're not the person, because all you need is a probable cause determination. At least that's the typical rule. So that's one thing. But getting a witness to conform their answers could be seen as witness intimidation or witness coaching, which could be procedurally improper. So let's read a little bit more. It is a felony criminal offense for any person, including a district attorney, to engage in witness tampering. This is true. Using the police report from the lead detective in the case, Perry was previously able to detail a timeline of events which appear to rise to the level of witness tampering. Still, in anticipation of the hearing set forth by the court, the defense believed it was important to personally interview Detective Fugit, given the seriousness of the charge. An affidavit executed following the interview is, to say, troubling, and details the criminal behavior engaged in at the direction of the district attorney. All right, so we've got some potential issues here, but not necessarily, because there's a difference between, there's a difference between helping a witness and coaching a witness, right? So one of the things I can do as an attorney is what I can't do is tell you, like, I can't change your testimony, but what I can do is I can craft the questions in such a way and then instruct you to answer them consistent with the question such that you're not lying, right? I can't get you to lie, but if you're going to give me an answer that is more than I want, I can change the question, right, to get less than what I want. So I can have you give answers that are in conformity to the question. So there is a difference between, helping a witness and formally coaching a witness. So the prosecutor may or may not have acted improperly depending on exactly what they did. It can get into the weeds. Detective Fugit has a long history as a dedicated homicide detective. In this case, his investigation concluded that Perry acted in self-defense and that Garrett Foster was a criminal killed in the commission of a crime. Fair enough. I mean, that's one reasonable conclusion by somebody. Nevertheless, he was forbidden from presenting that evidence that allowed him to reach these conclusions to a grand jury, which is not an abrogation of the typical rule. The prosecutor only needs to get to probable cause. So in the absence of some specific obligation, he doesn't need to present this witness, which is bad for him, to get to probable cause. Instead, Garza was misled the grand jury and fed half troops divested by the family's personal attorneys, which again might be perfectly proper for a grand jury proceedings. Grand juries are treated much differently than petit juries, which is the typical jury, because it's a part of an investigation process. Detective Fugit makes it unequivocally clear in his affidavit that he was a victim of a felony offense of witness tampering in connection with the grand jury testimony, and the tampering occurred at the direction of Garza. In his affidavit, Fugit describes a time when, in his mind, Garza's behavior went from highly unethical to criminal. This occurred after Detective Fugit asked about ramifications of him ignoring suggestions to eliminate all the exculpatory evidence from his presentation. He is nevertheless ordered to comply with the directive that be one-sided grand jury presentation. This is, again, it gets into the weeds, right? It gets really into the weeds. If I narrowly tailor a question as an attorney, and I narrowly tailor it specifically to avoid you talking about other things, then I can ask you to limit your response to the question. In this case, there were foreseeable consequences if I did not comply and tailor my grand jury presentation as directed, and failure to do so would affect adversely my relationship with the district attorney's office. I was afforded no choice to comply with these directives. Fortunately, the court has the power to determine the extent of misconduct in securing it. They sure do. Moreover, the integrity it demands. Yeah, so this may be a very reasonable thing for the trial court to do. Held some kind of hearing, which might be formal, it might be informal, but to find out exactly what the prosecutor did or did not do and find out if it's inside the line or not would be a thing the trial court could do. Yeah, but it also seems like the detective over here has no problem telling his own opinion when he's asked the right questions. So it may be a kind of no harm, no foul kind of thing for the judge and say, well, you can ask him about that at trial and he can opine about the mean prosecutor and opine about the stuff and then tell you his real opinion. So we also have a second motion, a motion for evidentiary hearing in support of a motion to dismiss based upon prosecutorial misconduct for retaliation and obstruction of a witness. All right, let's read on and see what we've got. As detailed below, Daniel Perry now has additional evidence to support the claim that the district attorney did in fact tamper, and consequently asked the court to reconsider the motion for the evidentiary hearing. So apparently, in response to the prior motion, what the district court basically said is no, probably on a kind of no harm, no foul basis, because you can ask all this at trial. And the law isn't clear about what happens at grand juries. So district court said apparently no, or trial court said no. So the defense has now developed evidence that Garza was not content to simply tamper with a witness. Indeed, it now appears he's attempted to retaliate as a result of an affidavit they signed, as well as obstruct defense against access to them going forward. That is a bit of a problem. Moreover, as outlined below, the detective has received an order to no longer speak with the defense. Really? And undersigned attorneys do not want to cause detective any further retaliatory evidence. Yeah, that's a problem. The standard rule is that the defense has access to the witnesses, if it wanted to. In addition to cross-examining the person, they could at least theoretically call them themselves on direct. So they're a witness that's available to anybody. So if they're being denied access to the witness, this poses some potential real problems. So let's read some more. On August 3rd of 2021, Sergeant Perry filed his second supplemental. A mere 21 minutes later, Garza called the acting chief of police. Okay. From there, through the assistant chief, they threatened disciplinary action against the detective in order to never to speak with the defense attorney in this case. Now, that isn't necessarily the prosecutor necessarily doing it. It might be the chief of police doing it. But either way, that poses a problem to the prosecutor because now they're interfering in a criminal case. As is the usual practice, Detective Fugit took copious notes regarding the interactions. It's always good as a cover your ass memo. Of significance, here are following notes of the meeting they had with the assistant chief. So these are contemporaneous notes. Cover your ass notes, always good to have. So the assistant chief told the detective that he threatened internal affairs complaint was in direct response to him getting his ass chewed by the district attorney. Told Detective Fugit that they were attempting to curry favor with Garza and the efforts to be named as a new police chief. Told him the detective had threatened disciplinary complaint would not have happened if the detective had not come forward with the accusation of witness tampering. Noted that the chief gave me a direct order that I not speak with detective's attorney without a court-ordered subpoena. This is a problem. It's not necessarily clear it's a problem for the prosecutor, but it might be a problem for the chief of police because that would be obstruction. Somebody did a bad. In deference to this retaliation, we've not attempted to speak with him since then. But if it's true, it presents a problem. Texas Penal Code makes this a third-degree felony to harm or attempt to harm a potential witness by means of unlawful act. For the purpose of the statute, harm can mean anything related to loss, disadvantage, or injury. The act of retaliation can be committed using a third party. Yes, that's true. It can be. So whether or not this goes to the prosecutor or not is still an open question. The current tendency in the criminal law is direction of discovery of facts before trial and elimination of surprise. Yeah, the prosecutor isn't supposed to have any surprises, as we learned from my cousin Vinny. We're not hereby saying that witnesses themselves are compelled to speak with defense counsel. We merely intend to prevent the prosecutor. Yeah, so if the witness refuses to speak with you, then that poses some problems, and you might be able to get some kind of order to compel. But yeah, that's a whole different set of problems than the prosecutor directly interfering. In an amended police report, the detective describes his meeting with members of the district attorney's office in preparation of the grand jury testimony. Moreover, within 21 minutes of the defense filing the Fugit's affidavit, Garza engaged in actions that are clearly unethical and violate of due process and due course of law. Maybe by contacting the chief of police and chewing him out for what? I don't know. So that might be a problem. And someone apparently has directed the detective not to talk with the defense. So that looks like an obstruction. That is improper. And they continue to oppose a hearing on the issue, which, maybe for a whole bunch of proper reasons. So that brings us to the end of these issues in the Perry case. So did the prosecutor do it bad? Unclear under the rules. The prosecutor doesn't necessarily have an obligation. Apparently it's an open question, which for the moment means that the prosecutor can go about it either way because it's open, right? So the prosecutor doesn't have to present exculpatory evidence, which is typically the rule. Again, you're only trying to get to a probable cause determination. So in states where you don't have to even go through a grand jury, it's like the police making a probable cause determination. Is there probable cause you committed it? There's also information that would suggest self-defense, but that is a defense, right? Is there evidence that you committed the crime? Yeah, right? You shot the guy, he's dead. So is there probable cause you did that? Yes. You do have an affirmative defense? Yes. But do they have to conclude that in the first instance to bring it to trial? No, not typically. Not typically. especially to a grand jury. So, this may well be proper for what the prosecutor did. I don't know. But to the extent that someone has ordered the detective not to cooperate with the defense, that looks like it is improper. So it'll be interesting to see what the court does in furtherance of this case. And at least for the moment, that brings us to the end of discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.